Moving on to the aggravating factors which will be submitted by the prosecutors in the court. The first one would be the prevalence or rampancy of offense. For the offenses such as kidnapping, housebreaking, theft, robbery, firearms would be imposed with a heavier sentencing by the court. In the case of PP versus Tan Eng Hock, the accused was released due to his good behavior bond for car stealing. On appeal, the court upheld the decision of 18 months of imprisonment for the rampancy of car theft. In the case of Sin Ah Q and others versus PP, the Singapore Court of Appeal reduced the life imprisonment of the kidnappers as the kidnappers does not cause any violence acts towards the victim. In the factors of previous conviction and bad records, here the prosecution will list out all the previous convictions of the accused together with the accused antecedents. In the case of PP versus Jafar bin Dawood, the court enhanced 18 months of imprisonment from the convictions of 8 months of imprisonment as he was under the possession of the same offense which was done in the 5 previous convictions matters. For the factors of the position or status of the offenders, it has been and strongest aggravating factors in several cases. In the case of Dato Haji Harun bin Haji Harun Idris versus PP, the accused, who was a Menteri Besar Selangor, was charged for forgery and criminal breach of trust. He was then charged under the criminal breach of trust, and here the deputy of the public prosecutor used his status as against him. Perhaps the federal court enhanced that 4 years imprisonment was charged for the second charge and 3 years of imprisonment was charged for the first charge, and said that the accused should be a good leader towards the country. In the case of PP versus Khairuddin, the increasement of imprisonment of 18 months and a fine was imposed towards the accused as he was the credit controller of the bank and he had imposed a breach of trust towards the employer. In the factor of use of offense, where a offense of heavier committed of offense have been imposed towards the victim, then a heavier punishment such as whipping would be granted by the court. In the case of PP versus Safian bin Abdullah and another, where the imposed of maximum punishment of life imprisonment was imposed to 2 accused as they were about to commit culpable homicide not amounting to murder. For the last factor, which is the mode of committing offences in act of brutality, in the case of Jaginder Singh versus PP, the accused was pleaded guilty for planting dangerous drugs in rival of a restaurant, and then he was imposed with a 2 years of life imprisonment. Therefore, on appeal, he had appealed against the imprisonment of 2 years. Perhaps the federal court upheld the decision of imprisonment of 2 years, stating that he might have done an act of convicting innocent people against the act that they have not done it.